Hello everyone, my name is Eva Indiana Christoffel and today I'm going to give an informative speech on the Stand Your Ground laws. Have you guys heard that many states are now reconsidering the Stand Your Ground law? What could this mean for us? Could it mean we lose our rights, or would it make our town safer? This could greatly affect all of us because it could mean you cannot legally defend yourself in a time of need. The law has been brought up numerous times in cases and news reports, and I've done extensive research on these reports, as well as the experts such as John McCain and Mark Randall. So today I'm going to help everyone understand the difference between self-defense and the Stand Your Ground law, and also how they relate. The Stand Your Ground law states that a person who is mortally threatened or being attacked has the right to defend themselves, as well as not having to retreat first. This law began on October 1st, 2005 in Florida. After the law was in place in Florida, many states also followed Florida's lead by applying Stand Your Ground laws in their states. The law states that a person who is in fear for their life or who is being attacked has the right to use deadly force to protect themselves. The law also states that a person does not have to retreat first, meaning a person does not have to look for a way out or try to hide from the situation. They can simply stand up for themselves and protect their lives. A person who is standing their ground can be exempt from criminal charges. Every state is different, though, when it comes to standing your ground laws. Many states have restrictions on what is considered legally standing your ground and what can be considered a charge. There's a difference between standing your ground and the castle doctrine. Currently, over 20 states practice the Stand Your Ground law, where the person does not have to retreat first. The Stand Your Ground law has requirements for the person to be legally standing their ground. In most cases, these requirements are the person has to have the legal right to be in the location, as well as must not be engaging in unlawful activity. If both of these circumstances are met, the person can be considered standing their ground and can be exempt of criminal charges. Currently, 46 states practice the castle doctrine, including North Carolina. The castle doctrine allows the person to defend themselves while on their property, again without the obligation to retreat first. Some states consider your car, your yard, or even the street in front of your house to be considered your private property when it comes to defending yourself. Chandler McLean points out that many states allow the Stand Your Ground law have higher homicide rates. While homicide rates may have gone up, the overall violent crime rates have decreased between the year 2008 and 2009. So as you can see from this chart, the red bars represent year 2008, where the yellow bars represent year 2009. This chart shows the number of violent crime cases in each state over the period of 2 years. So as you can also see, the crime rates have decreased over the year 2008 to 2009. These crime rates include murder crimes, robbery crimes, as well as aggravated assaults. All of these can be included in a Stand Your Ground case. The best example I can give of a Stand Your Ground case is one that my sister shared with me, who is a Winston-Salem police officer. She explained that a drug dealer sold a bad bag of marijuana to a buyer. The buyer later came back to the drug dealer's house with a samurai sword and threatened him. The drug dealer shot the buyer in his own house and was later charged with possession of marijuana and possession with the intent to sell. The drug dealer was never charged nor found guilty of charges of homicide or murder charges. So due to cases such as this one and the Trayvon Martin case, where someone was killed and the person standing their ground was found innocent, many states are reconsidering the Stand Their Ground law. In the first 5 years of the Stand Your Ground law in Florida alone, 93 cases appealed the Stand Your Ground law. 37 cases have appealed the law in the past year and a half. Statistics show that over 50% of these cases, the person who was standing their ground was found innocent. So due to the increase in cases involving the Stand Your Ground, over 24 states are now reconsidering the Stand Your Ground in their own states. So why are so many states reconsidering the Stand Your Ground law? Some believe that people could have not used illegal force and could have avoided the situation by choosing to retreat first. Others believe that non-lethal methods could have been used in place of lethal methods. Others believe that person standing their ground was not actually mortally threatened when they chose to defend themselves. There's a difference between self-defense and standing your ground. In the case of self-defense, it means you have nowhere else to go and you must defend yourself. This could mean you've tried to get out of the situation, you tried to hide from the harmful situation, and there's no way out. You fear for your life and you must stand up for yourself or else possibly die. The difference between standing your ground is when you stand your ground, you do not have to retreat first when you fear for your life. Instead, you can go ahead and react and defend yourself, regardless of the situation, as long as you stay within the state's regulations. Although the stand your ground cases vary from state to state, many believe the law needs to be more regulated. The stand your ground law has been adopted by many states, but because the states have different restrictions, the stand your ground law can also be difficult to know when and where the law applies. Due to the increase in cases involving the stand your ground, many states are beginning to review and redo their state's version of the law. States are reviewing the law to ensure people are mortally threatened before defending themselves and using a lethal force, and also to ensure people are retreating first in applicable states. Although the stand your ground law is necessary in many situations, many still believe that the law should be reviewed or even terminated. Thank you. Are there any questions?
When was the stand your ground laws implemented?
Stand your ground laws were implemented in 2005, and then other states began after that adding regulations to their states.
Does North Carolina participate?
North Carolina is not part of the stand your ground, but they do allow the castle doctrine, which allows you to protect yourself in your own home and includes your yard in North Carolina. Are there any other questions? Thank you, guys.